sénateurs, je déclare ouverte la 30...
Honorable Senators, I now call to order the meeting of the Standing Senate Committee on Human Rights for the 39th time and the 41st Parliament. It is this committee's mandate to consider Canadian human rights and human rights abroad.
These committee hearings are open to the public and also available via webcast on pal.gc.ca website. You can it's on webcast on pal.gc.ca. You can find more information, the schedule of witnesses on the website under Senate committees. Honourable Senators, we are conducting a study on Bill C-304, an act to amend the Canadian Human Rights and to repeal Section 13 of the Canadian Human Rights Act, which makes it a discriminatory practice to communicate via telephone, telecommunication, undertaking or computer-related methods such as the Internet. Any matter likely to expose a person or persons to hatred or contempt because the person or persons are identifiable on a basis of prohibited ground of discrimination, example, race, ethnic origin, sex, or sexual orientation. This section has primarily been used by complainants in cases before the Canadian Human Rights Tribunal to address racist hate propaganda on Internet sites. Criminal sanctions against the propaganda are also found in sections 318, 320.1 of the Criminal Code. By repealing Section 13 of the Canadian Human Rights Act, Bill C-304 would prevent any cases of hate messaging from proceeding through the Federal Human Rights Commission and tribunal process. It would not, however, affect the prohibitions against hate propaganda in the Criminal Code. My name is Mubina Jaffer, and as the chair of the committee, it is my pleasure to welcome you all to this meeting. Before we continue, I would like my colleagues to introduce themselves, starting with the Deputy Chair. And we have a number of colleagues who are not normally members of this committee, and I welcome you for your interest in this issue. We'll start with the Vice Chair.
I'm Salma Tawlajan, and I represent Toronto, Ontario.
Senator Ngo, Ontario.
Senator Victor O, Ontario.
Don Oliver, Nova Scotia.
Art Eggleton, Toronto.
George Baker, Newfoundland, Labrador.
Senator Elizabeth Hughley, PEI.
Jim Munson, Ontario.
To begin our hearings today, we welcome Mr. Brian Storseth, Member of Parliament and sponsor of Bill C-304 in the House of Commons. Mr. Storseth, I understand that you have some opening remarks to present to us, and then you will be available to answer the committee's questions. So may I please ask you to start, Mr. Storseth.
Thank you very much, Senator. Can you hear me? First of all, I'd like to thank the St. Paul Education Regional Division for the use of their video conferencing technology that's allowed me to present to your committee back home in my riding rather than having to come back to Ottawa. Madam Chair, to begin, I would like to thank you and the committee for the opportunity to discuss my private member's bill, an act to amend the Canadian Human Rights Act protecting freedom. This is an issue which has been near and dear to my heart for a number of years, and I am thankful to have received support from a large number of my colleagues, as well as numerous media outlets and members of the general public on this important and often overlooked issue. This bill will help protect and enhance our most fundamental freedom, the freedom of expression. Without freedom of expression, one must ask themselves, what value does freedom of religion or freedom of assembly hold in our democracy? Freedom of expression is truly the bedrock upon which all other freedoms are built, and Section 13 of the Canadian Human Rights Act directly erodes this fundamental freedom. Section 13 of the Canadian Human Rights Act has been a contentious topic for a number of years and has been widely acknowledged that it impedes on Section 2B of the Charter of Rights and Freedom, which states that every individual has the freedom of thought, belief, opinion, and expression, including freedom of press and other media communication. This confliction between Section 13 of the Canadian Human Rights Act and Section 2B of the Charter was reaffirmed in 2008 by Professor Richard Moon, who was handpicked by the Canadian Human Rights Commission to review this act, when he stated on page 31 of his report that the principal recommendation of this report is that Section 13 be repealed so that the censorship of hate speech is dealt with exclusively by criminal law in Canada. It was reaffirmed once again in 2009 by the Canadian Human Rights Tribunal itself, which found Section 13 to be unconstitutional. Over the past few months, I have had many opportunities to attend a number of conferences, general meetings, and opportunities to discuss my private member's bill with Canadians at large. The implications of Section 13 on most people are astounded when they hear that our fundamental freedoms can be trumped by a quasi-judicial body that feels something you said was likely, and that is the key term in Section 13, likely to have exposed another individual or group to hatred or contempt. Canadians find it difficult to believe that such a loosely written and vague law has the power to undermine the fundamental rights that Canadians so proudly base their democracy upon, which men and women have given their lives defending for many years. While Section 13 of the Canadian Human Rights Act may have been implemented with well-meaning intentions, in an effort to combat discrimination and hate speech, its implications have reached much, much further, and it has become a sword against our fundamental freedoms and those human rights. Madam Chair, I am proud that my private members' bills received support from all different religious groups across the spectrum of ideological organizations and indeed even media publications, from B'nai B'rith Canada to the Muslim Congress, Catholic newspapers to the Toronto Star and the National Post, PEN Canada have all said that Section 13 of the Canadian Human Rights Act needs to be repealed. Because it is through freedom of speech and expression that we change governments in this country, not through riots and revolts. It is how we test societal norms and how we successfully develop and change our democracy. It is through the freedom of expression that we have shaped and will continue to shape our great nation. I would like to challenge this committee to look beyond the intent of Section 13 of the Canadian Human Rights Act and truly examine the structure and implications and consider what we as a free and democratic society are willing to give up. I'll end with a quote from Voltaire as he said, "I may not agree with what you are saying, but I will die defending your right to say it." Thank you, and I look forward to your questions and comments.
Thank you, Mr. Storseth. We will start with Senator Munson.
Thank you very much for being with us this morning. There are obviously, in terms of all freedom of expression, different points of view. It's my view that with freedom of expression comes responsibility. Under the Charter of Rights and Freedoms, you mentioned the B'nai B'rith. B'nai B'rith Canada also said in a study that it sees that, quote, the use of every new piece of web and mobile technology to spread hate through such incidents are now becoming so commonplace that the reporting of cases is not expected to keep pace with the reality online. Why? I guess it's a why question. You want to get rid of the Section 13, but isn't Section 13 sort of a safety valve for those who feel that white supremacist groups and others can walk right through this and use the internet to create more hate in the world and in this country?
Thank you, Senator. First of all, I would suggest that the repealing of Section 13 will not incur more hate in Canada, nor will it incur more hate speech in Canada. In fact, this section, since it's passed through the House of Commons, and indeed even before that, has really not been used by the Human Rights Commission, and I don't think we've seen an uptick in the number of hate speech that Canadians are reporting. But more importantly, I think that it is crucial that for those instances where real hate speech and hatred and harm is being caused through speech, I think it's important that real judges and real courts with real lawyers and an open system and a transparent system to the public is available in our country, as it is under Sections 318 and 320 of the Criminal Code of Canada, rather than through a quasi-judicial body that nobody actually sees and actually oftentimes trumps many of the civil liberties that Canadians take for granted, such as due process, the right to face your accuser, presumed innocent until found guilty. These things are all trumped when it comes to human rights tribunals. And indeed, Section 13's clause in the term likely to have exposed is something that leaves large loopholes. Indeed, it was a Liberal member of Parliament, Keith Martin, in the previous Parliament that brought this issue forward, suggesting that it was time Section 13 be repealed.
You talked, well, thank you for your point of view. You talked about the criminal code, but a group, the Canadian Bar Association, who would have to deal with the criminal code as described, Section 13 as one tool in the toolbox, and has described it, to combat intolerance. And rarely do these cases ever get to a major court of law. Also, what do you say to the Canadian Bar Association? In an article they posted, they said the debate surrounding the expediency of Section 13 has become the proxy for an open assault on the very existence of an administrative framework to protect human rights in this country. I come back to that question again, though, about it seems that those who would be rubbing their hands in glee today would be those white supremacist groups who will use every tool in their toolbox to propagate hate.
Well, I guess I appreciate the opinion that you have on that, but from my perspective and my discussion with Canadians, those that are rubbing their hands with glee today are those that foster and vigorous debate in our country. And one of the key points of this is the fact that it does curtail freedom of expression, especially online, which is where young people are going today and where the future generations will go to have debate in our country. And indeed, as I said, the organizations that have loudest supported this legislation are organizations like the Toronto Star, the Globe and Mail, the National Post. These aren't organizations that support white supremacy.
We have a lot of senators. Thank you very much for this round. Thank you. Thanks very much.
Thank you, Madam. Thank you, Madam Chair. And thank you, Mr. Forthas, for bringing this bill forward. I know that your issue is the protection of freedom of expression, and your main concern is that you state it impedes Section 2B and of the Charter, and there have been two senior members of the Senate of Canada, one of them the Speaker of the Senate, and another, Pierre-Claude Nolan, also a lawyer, very interested in constitutional issues, who have spoken, as you know, in the Senate on your bill. And I would like to read from each of their speeches and ask you to comment on what they had to say. First, Senator Kinsella, who, as you know, established and was the chairman of the Human Rights Commission in the province of New Brunswick for more than 20 years and is internationally known as a great human rights advocate and expert, said the following when he spoke in the Senate, and I quote, "The role of our human rights commissions across Canada, provincial, territorial, and federally, does not have to have them deal with civil and political rights, economic, social, and cultural rights, but more directly with what students of human rights would refer to as equality rights. Equality rights are best promoted and protected by anti-discrimination law." And he ended his speech in the Senate that day with this question. Do we really not want to have a statutory provision to deal with discrimination on the Internet? Now that's Senator Kinsella. I'd like you to speak to what he had to say. And while I'm still on my feet, I'd like to read what Pierre-Claude Nolan had to say. Pierre-Claude Nolan, as you know, talked about the Supreme Court decision in 1998, and he talked about directly what the court said about protection of freedom of expression. And he said that the Supreme Court recognized that this did indeed violate freedom of expression, but it also said that respect for the dignity and equality of individuals, especially as members of a particular group, minority groups he's referring to, justifies limiting this freedom of expression. So the Supreme Court found that there is some areas where there is justification in putting some limits on that. So I would like your response to what those two seniors had to say in the Senate. Thanks.
Thank you very much, Senator Oliver, and I do have a lot of respect for Senator Kinsella and Senator Nolan. Going in reverse, I would say I did have the opportunity to read both speeches in the Senate. I was very pleased that the Speaker of the Senate would take the time to talk on my private member's bill. In regards to respect in our society and the the comments that Senator Land made, I would suggest that it's difficult, if not impossible, to legislate respect. I think that is something that we need to make sure that we incur in our society through the winnings of hearts and minds. That's not something that, it's like saying that we're going to monitor people's thoughts and their expression. We need to make sure that, as the Charter says, and I do agree with the Supreme Court when it states that there should be a limit, and indeed in our country we do have a limit on what you can say. That limit is when what you say becomes harmful or is hate speech, true hate speech. These are very serious offenses that should not be swept under the rug and looked at through a quasi-judicial body. These are things that when people are actually doing this in our country, we need to take the time to ensure that they're tried properly in a real court of law with a real judge and real lawyers. We can't have some quasi-judicial body that nobody ever hears about. And these cases where nobody ever hears what the result is or hears the process in which it's undergone, the best way to address these issues is to shine light on it. That's the best way it's always been in our society, and I believe that's the way we need to continue to do it, and that's through the Criminal Code of Canada. The Criminal Code has a tried and tested method throughout the history of our country in addressing grievances that Canadians have. I would suggest that these quasi-judicial bodies that the Section 13 tribunals occur under really do impede on our civil liberties as Canadians, and I don't think anybody would suggest that that's the way that we should be trying these things. The other aspect I would talk about is Senator Kinsella's speech often talked about the intent, and definitely it addressed the fact that, and I do believe that the intent of the creators of Section 13 intended to defend human rights of individuals. But the way it has actually worked over the implementation of it is actually inceded on the human rights of Canadians, and that is why you have groups like B'nai B'rith Canada, the Canadian Muslim Congress, the Catholic Women's League saying, we agree with the intent of this legislation, but in reality it's been flawed and it's not worked to the betterment of Canadians, and it is, instead of a shield, it has been a sword that has attacked human rights in Canada. I would suggest, Senator, that these types of issues need to be addressed in an open, transparent way, and that is through the Criminal Code of Canada and our judicial system. And I would also add, one of the reasons why we put a one-year implementation period in this bill was so that the government could have time to look at beefing up sections 318 through 320 of the Criminal Code, which Minister Nicholson in the House of Commons has already said that they would do when this legislation actually gets passed.
Mr. Baker? Sorry, Senator Baker.
Yes. Thank you for your presentation. First of all, your point that the section violates the Charter. It's not unusual for a section of law to violate the Charter. That's commonplace. The point is it's saved by Section 1 of the Charter, and that's been determined by the Supreme Court of Canada over and over. Let me give you a quote from the Supreme Court of Canada that says that Section 13 is quite different from the Criminal Code. Shouldn't be confused with the Criminal Code. Let me give you a quote from 1990, which was verified again about 3 months ago by the Supreme Court of Canada. First of all, Canada versus Taylor, which case you're familiar with. It says this at paragraph 37, Supreme Court of Canada. It is essential, however, to recognize that as an instrument especially designed to prevent the spread of prejudice and to foster tolerance and equality in the community, the Canadian Human Rights Act is very different from the Criminal Code. The aim of human rights legislation and of 13.1 is not to bring the full force of the state's power against a blameworthy individual for the purpose of imposing punishment. Instead, provisions found in human rights statutes generally operate in a less confrontational manner, allowing for a conciliatory settlement if possible, and where discrimination exists, gearing remedial responses more towards compensating the victim. Supreme Court of Canada 3 months ago, at paragraph 105 in Whatcott versus Saskatchewan Human Rights Tribunal, again referenced with approval that distinction and the value of our Human Rights Act, Section 13.1. You are eradicating Section 13.1 with this legislation. What do you have to say about this opinion of our Supreme Court of Canada?
Well, first of all, Senator, I appreciate the opportunity to talk to you about this. I would suggest that, first of all,
Mr. Storseth, I don't mean to interrupt you. We've only got about 7 minutes, and we've got a number of senators, so I'm going to ask the questionnaire and also the answers to be tight, so other senators can also ask you some questions.
Thank you. Thank you, Madam Chair. I will keep my answer to this short. I would actually respond by Professor Richard Moon, who was appointed by the Canadian Human Rights Commission to investigate what he thought should happen with Section 13 of Section 13 of the Canadian Human Rights Act. And on page 31 of his report, he actually says, and I quote, "The principal recommendation of this report is that Section 13 be repealed so that the censorship of internet hate speech is dealt exclusively with by criminal law. A narrowly drawn ban on hate speech that focuses on expression that is tied to violence does not fit easily or simply into a human rights law that takes an expansive view of discrimination and seeks to advance the goal of social equality through education and conciliation." I look forward to having more vigorous debates with the Senator afterwards.
Mr. Storseth, we have 3 senators, and I will ask them to ask the questions, and then in the end, if you can answer them all, because we have very limited time on video conference. So we'll start with Senator Atulajan.
Thank you, Chair. Thank you, Mr. Storseth, for being here this morning. Scholar Isaac Berlin differentiated 2 types of freedoms in his 1958 essay, Two Concepts of Liberty: positive freedoms, the capacity to do as one chooses, and negative freedoms, freedom from external restraints or interference. Having lived under the Bolshevik rule in the USSR, Berlin was of the opinion that the pursuit of positive freedom could lead to the infringement of rights. He stated, "Freedom for the pike is death for the minnows. The liberty of some must depend on the restraint of others." You stress the importance of protecting the positive freedoms of Canadians in the form of freedom of expression. Does this take priority over protecting Canadians' negative freedoms?
We're going to have the 3 questions, and he'll answer them.
The Bar Association points out that by removing Section 13, we take away the civil standard of balance of probabilities and consideration of hate speech cases, and rely on the criminal code, which has a higher burden of proof. They're suggesting that, in fact, a lot of these matters can be settled at that level. And I know you don't have a great opinion of how these are dealt with by the tribunals or by the Human Rights Commission, but are there not other, have you not considered other methods of amending the Human Rights Act to be able to accomplish your aims, as opposed to going this route of which one could call throwing out the baby with the bathwater?
Senator Hubley.
Thank you, Madam Chair. The Moon Report presented other recommendations, including changes to the wording of Section 13 to include an intent requirement and to specify that the prohibition applies only to the most extreme instances of discriminatory expression, namely those that threaten, advocate, or justify violence against members of an identifiable group. I would like to have your opinion on those other options.
Mr. Storseth, if you can answer all the 3 senators at the same time.
Thank you very much, and I do appreciate the opportunity to discuss this with each of you, and I will avail myself to continue to be available when Parliament resumes, or before that, to have further discussions, as I have with with senators in the past. And I would like to say, to begin my final comments here, that I do very much appreciate the work that my late Senator, the Honourable Senator Finley, did in promoting this piece of legislation, and the work that he did with me in helping it get through the House of Commons as well. I do very much appreciate the comments made by the senators, particularly a couple of comments deal with potential amendments. And indeed, both in the House committee and through Professor Moon's report, he did state that the number one recommendation he had was the repeal of the section because it was so burdensome to actually amend it. And if you look at the amendments that were suggested, I believe there was like 12 or 13 of them in a very small section of the Canadian Human Rights Act, you would actually be overhauling it to such a point that you're taking a flawed piece of legislation and trying to change it so substantively that I think you'd be far better off to actually repeal the section. And if somebody wanted to, if a government wanted to in the future look at another method in protecting it, there may be other ways to go about it. But it is, I think, been acknowledged by most organizations that have dealt with Section 13 and reviewed Section 13 that repealing it is actually easier than all of the substantive, quite substantive amendments that you would need to be able to actually address the concerns that we have with it. You know, in regards to the question versus positive versus negative freedoms, it's an excellent question. I think one of the key fundamental differences in our democracy from some of those other countries that were talked about that were not democracies is the fundamental belief that Canadians, that the government has a responsibility to Canadians to allow them to express their disagreements with government position and the actions of the government. I think this is a core way in which we have and will continue to peacefully change and adapt our country to and develop a stronger society once we get to it. You know, I often use the example of Nellie McClung and the women's suffrage movement as an example of something that was societally, if you look at the Hansard of Canada, both in the House and the Senate, you'll see that it was not the norm at the time to talk about women's suffrage. It was actually something that many people found quite offensive. But it was through freedom of expression and freedom of thought that they were able to push our society to become a better place. And I think that it is important that when we are going to limit freedom of expression, it should be done in a manner that is open and transparent, that respects the rights that civil liberties that Canadians have, whether it's due process, the speedy trial, the right to face your accuser, the right to know the evidence that is presented against you. And none of these are available under Section 13 of the Canadian Human Rights Act and the tribunals that follow. In fact, there's many instances where investigations took many years and the defendants were never known of who was purporting that they were breaching their civil liberties or who was actually, or what the evidence was. And it can be very costly to Canadians, and they don't have a right to a lawyer in these instances. I think these are all things that are very big flaws of this process, the system, and as a conservative and a libertarian, I believe very much that we need to take the shackles of government off of us when it will enhance and promote better speech in our country. To end with, Senators, I would like to say that I very much appreciate the Senate sitting longer into session to review my bill. I thank you for that. I thank you for the time that you're taking to do this. And I would also like to pass on my thoughts and prayers with those people in southern Alberta that have been very much affected by the devastating floods that we've had. And thank everybody for their well wishes and support. Thank you.
Thank you, Mr. Storseth. And Senators, we'll take a few minutes break to get the next presenter, Mr. Moon, on video conference. Thank you.